so funny to talk to her. I was like, I totally didn't expect to speak with her. Cool.
That's great.
And her daughter put a picture of her up on Facebook.
She's feeling pretty good.
She said it wasn't as bad as she thought it was. She didn't think it was as bad as it. Right now, she wants to just kick everybody out of the house. Right now, so she's complaining, so I did something.
I'll give her up then.
Because we had to miss classes because of the storms, we're a section behind. So this class, as I told you last time, we're going to do section 4, and then on the next class we'll do section 5, and we'll be back up to speed. I wanted to talk a little bit about the 2 rules that are listed for today first, which is rules 23 and rule 11. And in talking to some of you in the past, you know that Rule 11 to me becomes a really important rule that should guide a lot of your function as an attorney. And I actually think, and I strongly believe, that it's a good rule even if it didn't exist, because what it tells you that you must do prior to affixing your name to any pleading in court is that you have to make sure that the claim is sufficiently legally and factually meritorious. And what it means is that to some extent you have to be the gatekeeper for some claims as to whether they get access to court or not. I actually, I found this really amusing, but I litigated a case. We were defending it actually, and had said many times the plaintiff that, or plaintiff's lawyer, that the case was meritless and should be dismissed. But at any rate, he got all the way through trial, and we tried the case, and he lost it, as he should. Jury was out for about 45 minutes, including lunch. But even nonetheless, the case got all the way to trial, and there was some exposure there. And you know, anytime you get to trial, you have to consider the chance of losing, even though you, as I strongly believe, the case was meritless. But at any rate, having lost that suit, pulled the appeal, and then decided not to pull the appeal after paying our costs for the appeal as well, because we were insistent on the costs. He then turned around and sued his lawyer, the original lawyer in federal court, saying that the lawyer should have told him how meritless his suit was, and should have insisted, by the way, after paying the lawyer about $120,000, should have insisted upon him that the claim was meritless, he had no leg to stand on, and that should have, did a bad job for him by helping him pursue the claim. That if you knew this litigant, it was all him. He desperately wanted to pursue the claim, and he was fortunate enough to find a reasonably talented lawyer who did so. Having then lost both at the trial level and lost a lot of money to the attorney, turns around and sues the attorney, and my guess is then spends another $100,000 on his second frivolous claim, in my opinion, and lost yet again when that case went to trial. And a couple lessons to the story. I do still think the first case was meritless. However, even with a relatively meritless claim, got all the way through trial. We had to try the case, so some expenses on that side as well. So the fact is that if his lawyer had done I think a better job and told him that while the claim may have a little bit of merit, the likelihood of ever succeeding on that claim is remote. Plus, a lot of his testimony wasn't truthful to begin with. But I do think his lawyer did him a disservice by not insisting on it. But sometimes we also get stuck with a client that doesn't care what we think. If, you know, I'm not sure any of you would have been able to tell Jimmy that he couldn't go forward. And it's either you or someone else. And there's a long line between I don't think we're going to win and a claim that's really is completely devoid of merit whatsoever. But I wonder, and I actually wanted to, if I come across him, I'll ask him whether he regrets bringing the first suit, the lawyer. But because none of us like to be sued. If he had done a little more work with respect to Rule 11, that he may have avoided 2 years of aggravation after we left. Go ahead.
Just going to ask you though, isn't it, regardless of whether or not your client thinks it's meritless, you reasonably believe that it is, or the alternative, reasonably believe that you don't have a claim, isn't that your issue, and you shouldn't have taken it to begin with, therefore you be subject to some...
I think that's a good question. But see, here's where the problem comes in. There's a couple of interesting problems with that. You don't always know, well, you don't know the extent of how good or bad a claim it is until you've already invested some time and some of the client's money in it. I think it's harder once the client has paid you $5 grand, 10 grand, you've done your legal research, you've done your factual investigation, is then to give it back to them and say, well, I don't think it's sufficiently meritorious. Well, you took $5,000 or $10,000 from me. You could have come to that conclusion a lot earlier. And here's the question that's asked. I mean, this course is supposed to be a practical application of the rules and the law and questions that clients come in with. Are you telling me that I can't bring the claim, that I can't win the claim, or that you won't bring the claim, or you won't win? Because this happens a lot. As people will come in, you'll get the facts, they'll talk to you about the information, you'll look at some support, and I'll be honest, I can be really selective about what claims I choose to provide assistance on these days. Wasn't always like that. I didn't always have that choice when you work for a firm. Okay, but now I can be completely selective. But so when I give her claim back, saying, what are you saying if you're giving it back? You're saying, well, it's not for me. She doesn't have a claim. She doesn't have a claim big enough for me. Or you might, or I'm telling you, you might have a claim. You need to go find another lawyer, but it's not going to be me. Well, why isn't it going to be you? Because what?
I would say that you could be saying any or all of those things, right?
But I want to know, well, what is it you're telling me, right? I mean, if I were to do that with one of you, I think you might just put, well, so what are you saying, though? I mean, are you telling me I don't have a claim, or I do, but you don't think it's sufficiently good enough for you? And that's okay. I mean, because here's the problem, just so to lay it on the table. If you indicate that they don't have a claim, and they talk to someone a year later or 2 years later after the statute of limitations has run, well, now you might be getting sued anyway, right? Because you indicated there was none. There's another lawyer who says, oh, no, you had a claim. So what are you telling them? And whatever it is you're telling them, I know what you're saying, well, you could be all of this, so you can be ambiguous. I'm not so sure that you can. You may have a claim. You better get yourself another lawyer. I'm not going to handle it.
So if you decide not to take a case and you disclose it on those terms.
On what? I'm not taking this case.
I'm just not interested in the case. You're
not interested. Okay,
not interested. You're suggesting that you have to be more specific and say, I'm not.
Well, I think they make one. So you're not interested. Well, so you haven't taken any money.
I'm not the guy for you. I can't.
So you haven't taken any money from me.
Correct.
Okay, because I do think that's different too. If you're going to tell me after $5 grand you're not interested, well, now you probably have a complaint to the BBO, right? Your interest, you had interest in $5,000. You're not telling me it's not meritorious. You're saying I'm not sufficiently interested. Well, I think I'm going to be complaining and I want my money back. Look, right?
Yeah.
I mean, you got to think about, unfortunately, sometimes practicing from a defensive standpoint. And plus, listen, I'd be pretty angry if I give the lawyer $5 grand. Lawyer's not telling me it's not a good case. Lawyer's not telling me I'm just don't have an interest in it. Because my follow-up is, so is it, but I do have a case? And I can win? Or are you saying, no, I don't think you're likely to win, but you do have a case? Because that's the question here. You know, Rule 11, as you look at it, in the way I define it to you, right? It's not grounded in fact or law. You look at it, get out of the room, right? Those are easy. I've told you this. I've used the illustration. I had a guy come in one time. he broke his tooth eating ice cream on a piece of frozen bubble gum. He said he wants to sue. And I said, so well, what kind of ice cream was it? Frozen bubble gum. Get out, right? My kids, we were at Applebee's, I think, one time up in New Hampshire, Maine, and they're both the children of two lawyers. They bring my dinner. There's a nut and bolt in my dinner that you can see. It's about this big. Okay? I mean, it's like, I don't even know how someone could bring it to the table with a nut and bolt like that. I look down and I say, hey, the kid hadn't even left the table. I said, there's a nut and bolt in my dinner. And the kids are there, sue, Dad, sue. Now, I hadn't ingested a thing. I mean, it was an unfortunate experience, and I'm not even sure it happened back there to an Applebee's since. But I haven't suffered any damage. You would have think they'd still comp the meal. They didn't even comp anything for that. Can you believe that?
Wow.
So nothing. But that's, and some of them are easy. The problem is some of them are not so easy. And that's the problem as we sit there in Rule 11 is it's got to be so lacking in merit or so lacking in facts that you throw them out. But the fact is, even a group as esteemed as you has been wrong on occasion, right? So, listen, I don't think you have much of a case. But that doesn't mean that I'm not wrong here, and that doesn't mean that I or someone else can convince a jury that you're right. And that's the problem. When we look at Rule 11, it's that it's not sufficiently meritorious. That standard's probably relatively low, although I do think it's important. And I think it's even more important than the rule actually says for you to gather as much of this information going in, because the facts will still change as we go. Okay? I've practiced law for 30 years now. There's still going to be stuff you don't know when you start out, and there's still going to be stuff that as you get deeper into it, things sort of move around a little bit. Sometimes it's people's perception of what actually happened that it oftentimes is than what really happened. And so you need to look at objective information, and so you need to gather as much as that. And the problem, especially in remedies, comes in, when we talk about remedies, we're oftentimes talking about an injunction, and that means rushing off oftentimes very quickly because someone is saying they're suffering an immediate irreparable injury. You know, the emergency situations even more so, where you've got to remember the basics and dot your I's and cross your T's. Because you can't get into the swamp, be halfway up to your ass in alligators, and then realize, I shouldn't be here. Because now you're in trouble. And now you didn't do what Rule 11 said, is gather as much as that in advance.
Well, my question to you is, where is the threshold here? Because to understand whether or not you want to take a case, you probably got to do some type of investigation into it to collect the facts. You're going to charge the client, I think, or is that on your own?
That's a determination you have to start to make. But again, if you are charging for that, recognize you're charging me for it, and then you're going to tell me, see you later. That doesn't sit well. Especially as a new attorney, when people are first calling into your office and you or your staff are doing the intakes, you're going to invest a lot of hours that you may never charge off for. Well, just take a simple one. None of you have ever tried a driving under the influence case, right? None of you have. It's a relatively simple case. But the first time you have to research your statute, apply it to the facts, and start to think about, well, how would I prove operation? How would I prove public way? How would I prove all these things? And what question should I even ask the person as they come in? Because that's the big thing. You know, the first time someone goes, you've got a DUI coming in today at 2. You know, I got to go look at the statute. And you need to do that at the outset because you need to know what questions to ask. And the same, in DUI, at some point becomes relatively easy. It's only 4 elements, blah, 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 blah. Employment disputes, consumer frauds, class actions. Jeez, class actions, okay, I remember first year Civ Pro, but this sounds like it could quickly get way over my head. And federal court, state court, I mean, all of that, we've got to sit down and I've got to gather as much, but if you want to capture that client and appear knowledgeable, you're putting a few hours in at the outset simply before the person even sits down so that you can appear sufficiently knowledgeable about their antitrust action or their Lanham Act case or whatever it is. And that's probably free for for you. That's further investment in your education. Now, there will be times that someone will come in and you've done some of that, but still, well, before I can make a determination as to whether we really can go forward, if you want me to do it, we're going to need in advance, and there's no guarantee that we'll be able to go forward, or I'll be able to make a recommendation that you have a strong enough claim. But we're probably talking 10 or 12 hours here, whatever your hourly rate is. I need that to make a determination as to whether it makes sense to go forward. And if we go forward, we'll be talking about a further advance at that point. And I think if you don't spell all of this out, this is the problem, is then you're going to get complaints. And you just don't, financial issues are obviously a significant concern to the Board of our overseers, and not handling clients' concerns or complaints appropriately is as well. And you don't even want them to know your name. So all of this notion about the research, the investigation, the being careful with your name and your reputation, because at the end of the day, that's what it is. That means you either invest free time or you're a little more selective than you would otherwise, so people don't even get to come into the office. And some of that will be screening before they set foot in, and that's procedures you should have established. You want to check your conflicts, you want to check and see if the person has been in before, and if there are issues with that client. Maybe you don't even need to have them in. We've decided we're done with Mike Coyne's work. That type of work that he brings into the office isn't worth it. Go ahead.
At what point in your career could you say that you adopted Justice Potter's saying, "I know it when I see it," in terms of a meritorious civil action?
Oh. I'd say at least it was a few years out. I remember I was a paralegal and a law clerk for through most of college and law school. So I had done a lot of civil work before I ever became a lawyer. But even still, even with that, and I'm serious, I was in charge of the trial lists, and so I did a lot, even while in college and law school, with civil cases and getting them ready for trials and things like that. It still is more than a few years in before you really then can start to get the gauge of people as well, and be able to quickly make an assessment on whether the case is sufficiently worth going forward. Because sometimes, even the guy with frozen bubble gum, he's got a case, okay? Oh, he might have a case, say it was some other substance he breaks his tooth. Over time, short time, you start to realize what it costs to take a case to trial. What it costs if you're going to be paying hourlies, if you're going to need expert witnesses. Some of that you don't really have an assessment until you've actually done more of a few yourself as a trial lawyer. He's lost a crown. What the hell is that these days? 1,000, maybe even 2. Say it gets us at $2,000. So I can't sell you've lost a lot of work as a result of that. Disfigurement. Come on, it's $2,000. So there's a case. Assume it's a case. You're probably saying you could go to small claims, and you should. But that's not a claim probably likely that most lawyers would decide to take, even assuming the substance is foreign and didn't belong there and you could show liability, the damages aren't sufficient. And then think of the other part of it. Suppose you take it on a contingent. Now this is not Rule 11. This says they're meritorious. You take it on a contingent. You get a $10,000 claim. So your fee, the best case it gets is $3,300. I'm not trying to be a snob here, okay? But $3,300, I better be able to resolve that with a couple letters and most a complaint, because otherwise I'm losing money on it, right? If I've got to go to summary judgment or God forbid trial on that case, and I'm looking at damages of around $10,000, you've lost money as a lawyer. What do you?
Kucinich just sued for $150,000 because of a broken tooth.
But okay.
An olive pit.
An olive pit?
Olive pit, yeah. At a congressional cafeteria.
What?
In a congressional cafeteria? There has to be a meal.
Last month.
What was he eating?
It was some salad.
Was it
Okay,
with
well,
olives?
let's talk about that. Kucinich sues for $150,000 as a result of a broken tooth. I just told you what I think, and I still believe is incredibly accurate information. Would you sign that complaint? You're telling me you're broken tooth, and I'll tell you, if I were defended, I would absolutely sanction Rule 11 on that. Because, okay, listen, could you have more significant damages? Sure, sure, theoretically. But, I mean, first of all, you know, what would they be? Even if he needs a bridge, what are we talking about? $3 grand, $5 grand? For what? He had an olive pit in an olive. Part of that might be a risk you assume. I mean, they don't always get the pits out. So, would you all sign that complaint?
No way. Wasn't there a case in torts, the fish and the fish bones and the chicken chowder that Professor
Right.
Wright talked about? Yeah, I mean pits are in olives, bones are in fish.
So my question is,
Yeah.
why wouldn't you sign that complaint? It's $150,000, which is better than the $2,000 we originally It sounds like a better payoff, especially if we're talking about contingency.
But listen, I could have put $250,000 on my guy who's got the frozen bubble gum, but that doesn't make it so.
Right.
Right. And that's the point here is that you can put whatever number you want on it, but isn't that the type of problem that gives us lawyers a bad reputation? And that's what you have to decide. Okay, could you manufacture a claim to make it bigger? Sure. A lot of the lawyers handling those auto accidents in Lawrence did just that. Some of them went to jail. So that should be a consideration for you. And so the problem becomes is you are the screener. We've got a good liability case, we can make it worth more, or we can argue why we should get more. But at the end of the day, I can also tell you that defendants and their insurers, they do not just write checks out easily because you're a lawyer and you're threatening to sue. They have systems in place designed to evaluate claims and to make an assessment of liability and recognize that you may not be prepared to take it all the way to trial, or recognizing at some point that this claim isn't worth what you say, and sooner or later, we can weigh you down. I will guarantee you he's not getting $150,000 for that tooth, and he shouldn't get more than 5 figures at any rate. And I'm not even sure that there aren't additional limitations on the U.S. government's liability under those circumstances. So it's a kind of an interesting situation. It's also an interesting political situation, I would think, for him to be seen as one of these greedy plaintiffs, you know.
What could you possibly do to justify that amount of damages? I mean, what's the premise?
I don't know. Now John's going to have me look, as he always does. He'll probably send it to me, which is good. But it's going. I honestly don't know. That's the thing. You know, I don't know. And you could argue a younger person you could even argue for a younger person to get that type of money. That's the point, is I have no idea what he could possibly say that would even approach making those numbers reasonable.
He says he sustained serious and permanent dental and oral injuries that caused significant pain, suffering, loss of enjoyment.
Well, you know, I mean, dental pain is significant, and I'll give you some money for that.
Which tooth was it?
I don't know.
That makes a big difference.
Well, on appearance.
On appearance, or what if it could have been like, yeah, like sometimes like if you break a molar, the pain is different than if you break a front tooth, I would think.
But you have an obligation to mitigate your damages. So worst case, you've got a day of pain. No? Because if you don't take steps to go get it alleviated quickly, that's not on me, is it? I mean, first of all, you should imagine he's got access to some of the best health care in the world. He's not one of the rest of us sitting around the table thinking, how do we get an appointment with the dentist? He calls and he's Dennis Kucinich and he shouldn't have any issue getting in quickly. But how much are you going to give him? He's got an obligation to mitigate.
Maybe he's.
Go ahead, Francis. I'll come back.
Well, you know, what's your theory of liability? You're suing based on What, implied warranty, merchantability?
Yeah.
Fitness for.
Negligence.
All right, well, I, as defense counsel, I could see, going right to summary judgment on that case, just, before he even gets out of the box. The
Because of all.
Webster versus Blue Chip Tea Room, that was the
That's your other
Fishbone's case. And, that's a Massachusetts Supreme Court case, isn't it? Yeah, it is. So, I mean, that case isn't gonna survive in Massachusetts.
Yeah, I'm not sure. I mean, it isn't a foreign substance, it's a substance that would be consistent with food.
Objects found in dishes that are part of traditional recipes do not affect the dish's implied warranties of merchantability or fitness for a particular purpose.
It may have been unpitted to begin with.
Right, sometimes I hate that when they put the olives in, they didn't take the pits.
Well, I'm just
because
saying,
expecting
maybe you
Right.
got the salad bar and they are pitted olives. They just weren't,
So even less of a plate.
That's what they're offering.
We'll have to check Mr. Kucinich's later as well, but it is, I mean, it does get us into, because look, a couple of the articles, lawyers in their games are leading us down the tubes. Judge rejects a libel claim over Donnie Brasco movie, saying that the guy was libel proof, he was such a low life. And so I guess the $150,000 Kucinich 2 thing, how many of you would, with regrets, still nonetheless sign on saying, well, he's got a claim, maybe I'm a little on the high side, I know Dan is, I just want to know, maybe I'm a little on the high side, but you know what, maybe a jury would entertain that there's more pain and suffering than I would think, and who among us hasn't had a toothache and we haven't got a dime for it? So, how many of you would sign the complaint? Just one? I thought, 2, 3?
I didn't go up
Maybe
that.
not for 150 grand. I think you've talked me into it.
and that's the point right there is when we become the judges of the elasticity in terms of what is
Yes.
blatantly exaggerated and what's not.
Right.
And, so we might as well, if it's an injury, you kind of throw it in, and you always have that Rule 11 sanction over your head as kind of a regulator or the stick of cases that come into the system. But how are we supposed to know whether it's 80,000, 2,000, 50? How do you know where the numbers?
And just so you know, for most part, in Massachusetts and federal court here, and I imagine it's most places, is when you have a claim that's not for a sum certain, not a breach of contract where a specific dollar amount is available, when you file your complaint, you don't ask for a set dollar amount within the complaint. And so what it might be, I mean, it may be a liability case. Francis says he's moving to dismiss at any rate, or summary judgment. But even assuming we have liability, if you're asking me what do I want for the case, I might tell you I want 100 grand. Now, that's what I want. What's going to happen before this case is over is probably a lot less than that. And that may be what he's saying is, well, if you ask me to put $1 on it, not in the complaint, I'll put $1 on it, it's 150, because I can't go up from there. I only can go down, generally down from the first demand. Because when you go up, they go crazy. But things sometimes change, so the terms of trade get changed. Doesn't usually work. It usually gets ugly when that happens. But it can go up, but it's oftentimes not. So sometimes the thought is, well, I'll start high, I can drop it down. And so my first saying is, what would you take? Give us 150. And if it's not in the complaint, by the way, it's not subject to Rule 11. All I'm doing is filing my complaint. Will you ask me what I would like? I think the claim is worth 150,000. I think you've got to be careful, because I think it gets you into these issues that these cases are at
Could he
least
be
about.
basing part of his claim on the fact that he's a public figure? This could impact his success in getting elected to whatever office.
I would think
he's running
filing
on?
frivolous claims has a
Well, I know,
more
but I'm
adverse
just
effect.
saying, is that part of his rationale for his claim?
And you can't prove that he'd be elected again. There was a case in civil procedure where a politician sued for defamation and argued that he lost an election because of that, and the jury decided that you can't make that claim.
Well, it'd be hard to. We'll take a look at his later on. I want to ask you if I can let's do a little bit of the case Unoil versus E.F. Hutton, because and the rule has changed. Rule 11 has changed a little and significantly since this case. But I always like this case because this is Joe Alioto, who used to be the mayor of San Francisco, one of the preeminent antitrust lawyers of his time. And what he did is, well, I get the calls, and I know Professor Malaguti has done it as well. One of you guys calls us and says, listen, I got a great case. But I'm in over my head and I need help. They're kicking me around. Will you sign into my case with me? I guess as a lawyer, what do I, or someone of your friends brings you a case a few years back and says, hey, we were in school together. I know you do this stuff now. I'd like to work on the case with you. We just signed a complaint. Can I rely on another lawyer, their representations as to the quality of the claim? Would you rely on? So none, you won't rely on any of your classmates? You're going to do your own investigation even though they've already done one? Do I have to look at all the research they've got? I got to look at all of this? Or why can't I just say, give me your 10 best cases? Give me your 10 worst cases? Because I'm not reading all this. Just you guys were complaining about putting a few hours in before you decided to take a case. That's a lot of reading. Do I have to meet the client? Physically meet the client? What if they're, can I meet them over the phone? Can I Skype with them these days? Or do they have to be in the same room with me? What steps do I have to take with someone and someone's calling and saying, I've got a good case, I need help, I need it fast. So, because they want Joe Aliotto's name on the complaint, because then it gives it a lot greater weight. Oh, geez, this is one of the top antitrust lawyers in the country, we better be careful. When he's signing on, because he knows you get in early, you get even more money. So he signs in, and then what happens? Was his client an injured plaintiff during the relevant time period? No. He didn't buy, he didn't sell, he held, he's got no claim. And you've got 20 lawyers in this room defending this deposition on a complaint you signed, and we want to get paid for that. 300,000 lives back in 1986. What would they do to you? And this is another reason about the rule, because the money piles up very quickly here. So what would you do if your classmate or a lawyer calls you and I'd like you to sign the complaint? Everything from scratch?
I'd have a lot of questions.
Well, but so as long as she gives me the answers, I'm good, or is there some independent level?
I think you need to have some level of independent look at this. You just can't take.
What's that mean, though? In reality, what's that mean? Some level of independent look?
You have to be able to dig deeper than just take just yes or no for an answer.
So I'll take the complaint, look at the pleadings. You're going to look at all the pleadings, first of all, assuming the case has been filed, right? You better, in the judge's orders, because sometimes, especially in situations like this, you realize that it's a real hornet's nest you're getting into, and you're going to get whacked around early on here, because the judge may have taken a disliking to your friend who's calling you in, or the case, or the lawyer, and righting the ship is going to be not an easy challenge, and you better be aware of the storm you're riding into. So you better at least get all the pleadings in the judge's orders and verify that in fact is correct. What about that pile of research?
At a bare minimum, you've got to at least read the affidavits of the potential plaintiffs and the witnesses. That's got to be your baseline.
Okay. What about all that law, all those cases that they've got? Can't I just say, give me your best 5, give me your worst 5, and then I'd probably have to do a little research, independent research myself, don't I?
Are you talking about
the legal
potential
research?
plaintiff? Oh,
right. He's got a pile of legal research like this. That's what foot thick. When you guys do research, right? You come up with some cases that are really good, others that aren't, others that are, I don't know. Maybe I could work this into a brief or an argument somewhere, but it's really not that good. But if this is the only one I had, okay. But I don't have to read that case, do I?
I think you need to assign a paralegal, or are you going to do it yourself?
Well, paralegal. I couldn't rely on the lawyer more than the paralegal. Because I could see myself saying to you, if I were a judge, and you came before me, and I'm surprised more don't do it. Give me your best case. Give me your best case for your argument in summary judgment. One case. You should have a best case, shouldn't you? So if I got your 3 best cases, and I looked at them both, and then I did a little research myself, why should I look at all the stuff you really more or less discarded? Because listen, sometimes when I'm doing research, I am really not efficient. Are you guys really that efficient? Because sometimes I've got crap there, I print it off at the end, I'm thinking, why did I even print that one off? Right? You know what I do? I write myself little notes on the first page now. Because then I don't have to read the whole thing again. Good case, bad case, says this, says that, element of this. And at least when I look at it, because sometimes you have that pile at the end, when I look at it, I say, oh, I remember that one, and I don't have to read the whole thing again. And that's taken me about 25 years to figure that out, because when I'm at the end of my research trail, and I've got a pile like this, I'm thinking, I'm not going to read all those things again to figure out which ones I was discarding as I went mentally. So what, do I need to meet with that client, personally meet, phone call, Skype? I mean, you have, and this is part of the discussion this week, you have technology at your disposal that when I first started practicing law, we didn't. Shouldn't you use it? I mean, doesn't that give you an advantage? What do you got? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Wow. Probably what? More than 2/3 of us are using the laptop to access the materials. And God knows what else over there in Francis's computer. No, but so why not? Then use that technology. $500 plane trip to California round trip, plus maybe an overnight stay. Don't they Skype with that client? Isn't that good enough?
Maybe, but you can't. But Skype is good, but you can't really get a feel for a person. Well, I can't on a computer screen, but sometimes when someone is sitting with you face to face, you can read their body language a little bit better, see, get a feel if they're lying.
I think you can do that through a surrogate. I don't think you need
So
to.
phone call's not needed at all.
No.
A phone call's not going to do anything for
Well,
them.
that could help, maybe. I think you should. I mean,
You just said you had to meet with them in person because Skype wasn't good enough. Skype has to be better than a phone call, because now I got
Not
both.
necessarily. I don't think so.
How do you figure that? How can that be logical? One of which is I need to see them personally. The other of which is maybe a phone call's okay.
No, but you can get a feel for somebody over the phone. Well, I mean, you can just use
But-
the
but-
phone. I'm saying if you can't meet with them in person, you can call them on the phone, and because you have to set up the Skype business with them, so you get a feel for them over the phone.
Would you Google them?
What are you trying to accomplish?
Trying to make an assessment as to how much investigation you have to do to take this case so that you're satisfied comfortably that it's worth an investment of your time. You're also comfortable that your Rule 11 obligations have been sufficiently satisfied that you're not going to get sanctioned like Attorney Aliotto.
So you need to just keep doing as much as you need to do until you get to that aha moment.
Which is what? That's all. I'm wondering what your research is. I know what I do now. I'm wondering what you guys are seeing as a practical matter. Your steps will be to satisfy Rule 11 and we'll call it good lawyering practices are. Now Goody had when he took to the Supreme Court. Don't tell him I told you this. And I think the first time you saw the client was at the Supreme Court. And if you had seen that client at the outset, I don't think he ever would have taken the case. That's my read of it. But look at him and say, "You kidding me?" Don't you think there's something like that? Like, you said you want to get close to them to make your assessment. You might be able to just give me a still picture, and listen, I know that's not right, but you wanted to know how long it took till you could finally make assessments. Well, some of that is very judgmental and it's experience. Some of it's just age, right? We sort of know what we trust, what we don't trust, what we think we like and what we don't, what other people think they like and don't. I mean, let's be honest. I look at the picture and I've got the guy with the bubble gum and listen, Dennis Kucinich, you better not be, none of that money better be for disfigurement, right? He's just not a good looking guy. We're not giving him any money if that's the route he's planning on going. Go ahead.
I think you need to do whatever it takes to have that level of comfort that you believe in this
And
client.
what do you think it is?
I think
What is it gonna be for you, is what I want.
I think it means doing sufficient research. I personally Google anybody I have a concern about. You can find all kinds of things that is very cheap, it's very available. And I think the benchmark is gonna vary for the situation. You may feel very confident immediately with somebody, and you have sufficient, maybe the first few cases you reviewed of that big stat convince you, but if you can continue to find things that you don't feel comfortable with, it may take you a lot longer to get to that decision to say, this is not a case I can do. I don't think there's a cut and dry answer to that,
And
in my
I
opinion.
think that's a very fair answer, because, I mean, I'm not sure there is a bright line where we say, okay, that's where we can stop, or that's where that is or isn't enough. Except, let me just back up with that said, and I do agree with your point generally. Are there situations where you would envision you're signing on to a case, signing a complaint or an answer, without having seen your client in some capacity, either by Skype or personal meeting?
Yeah, I absolutely.
Don't you think that exposes you a little bit?
Yeah.
Because I would
It's
see when I'm
very
looking for
uncomfortable.
Rule 11, I would say, Your Honor, he didn't even personally see the client in any fashion prior to signing this plea.
But if you read the complaint, maybe, I mean, perhaps, other documents, or you talked to the other attorney who had met the client, I think you can make an assessment.
Yeah, I'm not disagreeing that it's case by case. To me, that's really important. But as I even asked John the question, I'm thinking, well, what if you had a serious burn victim and you knew they were, and they were hospitalized to the point where they really shouldn't see people? It's not physically safe for them to do so. But you know the situation and you were aware of it. Would that justify it? I mean, aren't there, I guess, are there and that's what I'm asking. Are there exceptions to the rule? And is that a rule? The rule is, listen, Mike's rule would be, I need to see the client. Because I'm a trial lawyer, okay? I'm taking a case to trial. Appearances are important. Whether I can sell what they're telling me took place. And I know it's horrible to say, but I think some people make their mind up before we ever utter a word. Right? And I know that's not right, but I think we do. Or does anyone want to take exception to that? I mean, it may not be right. Don't judge a book by its cover, but do we think that really doesn't happen?
My husband was on a jury, and it was a medical mal, and I wasn't in law school at the time, and he said the first attorney came out and was really frumpy and dumpy and talking to the floor, and they just figured we lost, and then the defense attorney, real slick, on TV, and he was really entertaining them. And then my husband said that the plaintiff's attorney was really slick, and the defense attorney was just frumpy and rumpled-sued and talking to the floor. And they had kind of all made up their mind until there was a crucial mistake. The plaintiff, it was for a child, and it's like birth defects, and I guess they made it seem like the poor child was like gonna be, completely crippled for the rest of his life and practically brain dead. And they brought the child in, and the child like ran into the courtroom and played with the judge and was sitting on the desk, and that was it. They said, forget it. And my husband he was telling me about, the appearance of the attorneys. He says, I can't believe these two attorneys and the slick guy. And you know what he said after a while? The slick guy was really fun, but he was getting old. His case he was just like, all right, we've seen it.
You gotta leave while it's still
yeah.
fresh.
So you're right. That's first, it's
Yep.
true. Lawyers and their games are leading us down the tubes.
I guess I'm wondering how you're gonna combat some of that. I mean, you're entering a profession to help, to serve, and I think it's, and I strongly believe it's a noble profession. We do great work at our best, but unfortunately lawyers can cause a lot of mischief sometimes too. So, how do you ensure you're gonna be one of the better ones? Are there things that you will do that I won't have to read about you in the newspaper? Or there are things that when I read about you in the newspaper will say, yeah, he's one of mine, she's one of mine. And I do that. And unfortunately, I read them both. And I pray when I see a lawyer article and it's not one of mine. Well, bad lawyer article that it's not one of mine. So I wonder, I mean, how do you figure you're going to be able to stay ahead of that curve and really be seen as one of the better lawyers, one of the good lawyers, not one of those other ones? Have you given that any thought?
I think a lot of it depends on what types of clients you take. I mean, we've had some, even the discussions in the class where we've decided we weren't going to take like certain clients and other people were willing to take them. And I think some of that kind of goes with your perception. I mean, like if you look at the, O.J. Simpson's trial, I mean, that was just, love don't fit. I mean, he had that whole.
I take that trial.
No, but I mean, you could take the trial, but
Yep.
the way he handled it wasn't necessarily the slickest. Well, it was slick because he got him off, but it just, I think it's how you present yourself and what integrity you use in the courtroom. You deal with what you got. You don't play the hand you dealt.
So how do you try and ensure that you're seen as the good one as opposed to being too slick, too fancy, trying to fool us instead of persuade us?
If you've done your work, you present the facts, say these are the facts, these are the laws, and there really isn't much to it. You don't need any games, you don't need any bells and whistles.
But we like the games and the bells and whistles. That's what entertains us, right? I mean, a good advocate has to use all the little tools within their disposal. You guys with all these laptops, I imagine someday you're going to be trying cases and you're going to be putting these big images up there and in color and everything, and you're going to get up there and you're going to show it. I mean, and I'll still be that old frumpy guy with the poster boards and just trying to keep up with the rest of you. I mean, you'll be doing that, won't you? So, but doing it for good, not bad. Go ahead.
I mean, for me, I think like having a good command of the facts and really knowing the case really well, it just kind of gives you a lot of confidence when you go in the courtroom.
No doubt about it.
So that, just your manners, and you go in the courtroom and you feel like you have a winning case and you kind of project that. And so that's, I think, really knowing the facts and really understanding the case to the nitty gritty.
No doubt about it. Lawyers who know the facts and the law better are more likely to be successful, time and time again. If you do a half-assed job and you don't really master the material, because it's a lot of material, or if you don't really investigate and have a good command of the law, you really, and don't know the rules, both the rules, civil procedure, and evidence, if you're going to do trial work and the like, then you're at a significant disadvantage. And you're not helping the client, and you're actually, more often than not, hurting the client's cause. And if you're lazy, and that's the thing I think sometimes early on you won't be lazy. Sometimes that you can develop, I hope not. If you are, it will only get worse over time. Because the lazy lawyers are the easiest ones to beat. They'll go through the motions sooner or later. I know that I got you because you're just not going to do everything you need to do, and when the time comes, this will be over appropriately. So can't be lazy. I tell trial students, and I tell you guys, and I think it's right. There's always someone smarter, prettier, more connected than you, but no one should ever outwork you. And I think that's the way you have to look at it. If you want to be a good or a great lawyer, you need to work extraordinarily hard. And you need to keep working while the other guy is shutting down at 5, 6, 7, or even 10 o'clock at night. And if you put that time in, I think there's a lot of work for good lawyers. But it's not an easy job, taking care of people's problems. And that's what lawyers do for the most part.
I think other than that, when I worked with Judge Chernoff over the summer, the one thing that I got out was to be nice to everybody,
Yep.
especially in the courthouse, and be courteous to everybody.
Yep.
And think the one thing he said, loose lips sink the ship, and it's just being courteous to everybody, because everybody, you know, you say something out in the hallway, you know, a court officer hears it, he tells the judge, and it just, I remember Judge Chernoff was telling me a story about how somebody had said, an attorney said that the judge didn't have the wherewithal to understand his argument, and he made sure to put that in the opinion so that the attorneys would understand. I thought it was pretty funny, but but I think one of the main things is, you know, having work ethic is being nice to everybody and courteous to everyone.
Go ahead.
Can I read from Robert Jackson?
Yes.
The county seat lawyer. He read in the commentaries of Blackstone and Kent, and not by the case system. He resolved problems by what he called first principles. He did not specialize, nor did he pick and choose clients. He rarely declined service to worthy ones because of inability to pay. He never quit. He could think of motions for every purpose under the sun, and he made them all. The law to him was like a religion, and its practice was more than a means of support. It was a mission. He was not always popular in his community, but he was respected. He lived well, worked hard, and died poor. Often his name was in a generation or two simply forgotten. It was from this brotherhood that America has drawn its statesmen and its judges. That was an essay written by Supreme Court Justice Jackson in 1950, the county seat lawyer. It wasn't the entire
No,
essay.
that's fine. Just send me that though. I think that's very well put. No? What are you shaking your head at over there, Mr. Fisher?
Cover me cynical.
Okay. Really, what a surprise. Well, go ahead.
I have to agree with the author of The Lawyers and Their Games. The lawyers are a plague on the land. They produce nothing. They're a leech on society.
And yet you want to become one.
I have no desire to become a lawyer. I've said that many times.
So why are you going to law school?
For my own edification, protection.
Protection from us.
Know your enemy is the Sun Tzu.
Do you really believe, though, that lawyers provide no benefit? Not even no. Do you really believe that many lawyers don't provide a significant benefit to society?
I'm a firm believer that one lawyer in town will starve to death, two will make a very good living.
Yeah, that's an old adage.
Yes, it is. And more truth than we care to admit.
And so you don't believe that lawyers provide a significant benefit to society?
I think the damage they do far outweighs the benefit.
All of them?
As a class.
Shakespeare had an opinion.
Yeah, but see, yeah,
Well,
go ahead.
Kill the lawyers.
No, first kill all the lawyers, but that reference actually is if you want to have a society where there is no freedom, then you first kill all the lawyers. So it actually is a compliment to the job that we lawyers do. Anyone? Go ahead.
Well, there are good lawyers and there are bad lawyers, and I've seen them all. My father is probably one of the most ethical lawyers you will ever come across. He stopped doing personal injury cases because he just couldn't stand it anymore. And that's why he's not one of the rich lawyers. He's just, and I'll tell you, if you treat people with respect, as you said, he's always telling me you treat the judges with respect, the other attorneys with respect, secretaries, paralegals, the FedEx man, and your clients, that you get a good reputation. And people will think, oh, you're a lawyer, but you're a nice person. You're not one of those lawyers. And also, you talk about ethics in trial lawyers. There's ethics in wills, drafting contracts and wills. I mean, I've seen things like that. Lawyers have drafted loan documents that are borderline unconscionable. And I'll have these ethical discussions. How can he do this? How can he do this? And he says, well, we can. It's And you see these things, and if you just say, no, I am not going to draw that loan document, with that, prepayment penalty that says everything but my firstborn child, even though I can, I'm just not gonna do it. And if you just draw that line, and you will bring respect to the profession, because people will say, yeah, he's a lawyer, but he's a good one. It just goes across, you just treat people the way you want to be treated. Unfortunately, sometimes you get burned, but, you go to bed at night and you feel good.
You asked I want to compliment what she's saying. You asked the online students in a question, what would the ideal qualities of a lawyer would be. So I took it upon myself to list my own,
Good.
and I want to share those with you.
Okay.
Love your profession. Have a real sense of dedication to the administration of justice. Hold your head high. Render and exact courtesy, honor, and straightforwardness at the bar. Respect the judicial office deeply and demand the highest standards of competence and disinterestedness and dignity. Despise all political use of or trifling with judicial power. And I think that's what one of my classmates mentioned a few minutes ago. What really offends people is this misuse of the judicial system. And if we as lawyers can adopt whatever qualities we feel are important to us, I think we'll gain the respect of people.
I agree with you, and I think, despite what John believes, I think the lawyers who are bad lawyers, who are really not doing appropriate work, are in relatively short supply in our profession. Most of us are toiling along the lines that Francis said, and they're not ever necessarily going to get rich. They're going to work very long days, and they're going to work hard days, and they're likely to be forgotten within a generation or two. But the fact is that if you go to a district court or a superior court, you see the poor people that need lawyers and need them desperately at that point, and without them, their liberties would be further restricted and they would be punished more severely. I mean, to some extent, and not just in criminal settings, civil as well, we have an opportunity to right wrongs. And so, and I am not naive, and I'm just not quite as cynical as Mr. Fisher yet, I think. But I am cynical in other ways, but I really do think that lawyers, as Lincoln, I think, said, have an enormous ability to do good work. And I think that's the way I hope you go into it, and I hope that's the way you think about it. But I do think that you have to start to make decisions now as to how you achieve that, and what you start to think about is your professional goal here. Because if it's just to be a lawyer, I mean, there's all sorts of lawyers, and they're going to fall into both classes, and you will either get a very good reputation quickly or a very bad reputation quickly. And some of the little things, being courteous, being respectful, taking your job seriously and working hard at it, those little things can really, and this proves John's point, can really set you apart from a lot of lawyers. And it's a shame that it just really does take so few things to really make you start to rise to the top in our profession. Being honest about the work you do and doing it well and working hard at it, I think really can help to establish a good reputation. Let me ask you about the technology part, because I touched base on it. But I really think that this is an important thing for you guys to think about while in law school, is that you will leave law school with a law degree and hopefully with some greater understanding of technology, that as you start to think about that first job or whatever it is, however you're going to be a lawyer, the fact is, if you start to use technology now, gain a better appreciation for it and a better capability of using it, that gives you an additional skill when you go looking for that job. Because a lot of older lawyers, we go to courtrooms, we talk to the clients, but I have people that take care of the technology aspect for me. To the extent that you bring the technology capability and the legal capability and the professional skills to that law firm, that gives me a three-for here. The fact is, you can keep track of your time on a software program. The fact is, you can help me with the e-discovery if you know how to do it. I mean, we used to do discovery with piles and piles of papers. Half my third floor is still a couple significant pieces of litigation. Papers piled everywhere, all over the building. With a scanner and your laptop now, you could probably, I don't even know what it is, millions of pages. Another software program, it would put them all into categories. You could be far more efficient than we ever did. If you're going to use it during trial presentations, you really don't need the blow-ups. All we need is a projector, and we can put it up there. What you need to start to do is figure out how technology can allow you, whether you're going to be in a small firm or whether you're going to be solo, how it allows you to be able to compete with much larger firms and much more experienced lawyers to use to your client's advantage. The other thing you have to start to think about with your computers and the rest of it is, well, marketing, right? I mean, to a large extent, you're new at this. So how am I able to get my name out there? How am I going to be able to market my services and have people know that I'm an expert in this or that area? One thing, for relatively short money, you should get your name, right? You can get a domain name for as little as $15 for 2 years. I have Michael L. Coin. It's nothing there, but I couldn't even get Michael Coin because that name is not as uncommon as it should be. So if I wanted to be this, I don't know who michaelcoin.com, but if I wanted to be Michael Coin lawyer, I probably could get it. But I don't know whether franciscoffee.com is there. I don't know whether you're
michaelcoin.com is there in Worcester.
Is it?
I'm pretty sure.
Okay. Huh?
Take him out.
No, but here's the point. Why not now? You know where you're going to be in 18 months or 2 years at this point, right? So whether it's nuclear sub lawyer or nuclear sub hates lawyers.com.
Actually, I've got John Fisher.
Oh, you do have John Fisher.
I do.
Good. See, so he can get his name for $15. You spend $15 on 2 drinks somewhere. You ought to think about whether it's family lawyer of New Jersey or criminal lawyer of New Jersey or God knows what it's going to be. But it's something to start to think about because you don't want to wait a year and then find out, okay, now how am I going to market? What you need to start to do now is figure out what the next phase of your life is. And if you go through Google cheap domains, then go to GoDaddy, they'll give it to you for $7.50 a year. Which is a discount even over their regular price. But we're talking short money to capture your domain with whatever name you ultimately choose to use as your website. And because I think realistically we all know that that's where most people go for at least some information these days. And probably be a pretty good place to start as you start to think about how you market your newfound abilities at being a lawyer. Go ahead, do you have a question?
No.
Oh, yeah, anyone have a question? Yeah.
Do we get any opportunities to work with technology, in terms of like PowerPoint? I've heard there's a program called PowerPoint for Lawyers. I don't know if that's different than regular PowerPoint. Do we get any opportunities in any courses to do that?
Yeah, there's Todd Cheeseman teaches at Trials in Technology, which would have some of that. It hasn't run, no one's ever wanted it. I didn't even know there was a PowerPoint for lawyers.
I just happened to come across it online somewhere. I don't know if it's different than regular PowerPoint.
We have a very basic sort of, introduction to the internet, which is now, it's an old course that if you don't know that, then there probably could be a more advanced technology, lawyers in technology. That's a good idea.
Because I'm coming from a university setting where, and most colleges have all kinds of
Right.
technology and
that's a good idea.
You're always presenting with PowerPoint and things like that, and I just wondered.
I think as a lawyer you got to be careful though. The use of PowerPoint is a discussion for another day with respect to its ability to persuade or as opposed to zone out. So we'll talk about that because I'm very careful as an advocacy piece using a lot of PowerPoint in court, or using PowerPoint in court period. We can talk about that next time. I wanted to just mention this first technology safety systems because here what they've blended is both the technology and the law, and what they've done is they wanted an ex parte seizure order. And so what they're using here is the litigation as a means of ensuring that the technology or the items, the evidence isn't lost because someone hits delete once they're aware of the items being needed. Now under the modern rules and the claims of spoliation, once litigation has begun, or if you know litigation is reasonably likely to be forthcoming, you as the lawyer, and you have to inform your client that they have an obligation to preserve information for the purposes of that piece of litigation. And if it's not preserved, it actually, you can be charged. A lawyer in Connecticut was charged with helping a client destroy a laptop. And he was sentenced to jail as a result of destroying that evidence. In Massachusetts, many other jurisdictions, there's a separate claim for spoliation of evidence, destruction of evidence. And if you think of how easy soft copy information is, in fact, attempted to be destroyed these days, you need to start to think about, well, how do I make sure we preserve it prior to its loss or its destruction? We represented a young woman who was the victim of sexual harassment, and we told her to download all the images and the information she got before she ever quit. Because once, I was certain once we told them that we were suing them, or would sue them, that the likelihood is all of that stuff would be deleted and destroyed, and now we'd have a massive job to try and go in and reconstruct all that information. So by the time she left the employ and we started talking about suit, we had all the evidence in our possession because we got it in advance. You need to think about that with soft copy stuff, or even hard copy, by the way, because you've got the letters, bring them in now. Don't, you know, if you think people don't throw away letters or destroy them, they do it both soft and hard copy. It's just easier with the soft copy to hit delete. And now we're talking about a major forensic job to try and recover some of that information. Here they went in with an ex parte order to seize, and the whole thing was kind of a mess on the impoundment and destruction. They allowed the plaintiff to be present while the item should have been impounded and preserved. But what I wanted you to look at this is to recognize that we can use even the court process itself to help us preserve information that we think might be likely destroyed or lost in the interim. And what this can do is really sort of put the other side right out of business right from the outset. And you ought to think about how we preserve the technology aspect of some of this information, because that's where stuff is these days. You're going to find it in email exchanges. You're going to find it. I got one now, and I specifically said, no texting, no phone calls, nothing. And I'm hearing that, and what I didn't say is no Facebook posting, which would, to me, would be pretty evident from what I said. Don't even talk to anyone other than me about this. But I guess people don't understand that means don't post your inner thoughts on Facebook when you're facing significant.
That's going to be a pain in the behind to deal with in the future. Like just the way.
Well, if you've got, people have to use more common sense.
Right.
You know, if you've got 250 friends that you're posting things to, those friends have friends.
Yeah.
It's a mistake.